Hello and welcome. I am happy to be with you here today, albeit virtually, at the Texas MGMA conference and on this cyber panel regarding hot topics and issues affecting medical practices. I am Corrine Smith, a healthcare attorney with the Winstead law firm. Winstead is a full-service law firm based in Texas. I am in the Austin office and practice in the corporate transactions group. My practice is exclusively devoted to the support of healthcare providers, including hospitals, physician groups, skilled nursing facilities, and ambulatory surgery centers. I advise clients on a wide range of issues, including practice operations, contracts, and regulatory compliance with HIPAA, STARK, anti-kickback, and Medicare rules. The topic of my presentation today is on healthy IT contracts, HIPAA, and beyond. I respectfully request that you hold any questions until the end of the presentation. You can then submit them electronically. These materials should not be considered as or as a substitute for legal advice, and they are not intended to, nor do they create an attorney-client relationship. Since the materials included here are general, they may not apply to your individual legal or factual circumstances. You should not take, or you should refrain from taking, any action based on the information you obtain from these materials without first obtaining professional counsel. And finally, the views expressed in this presentation do not necessarily reflect those of the firm, its lawyers, or clients. We can all agree on the importance of healthcare information technology contracts due to the sensitive nature of the data stored and the urgent need to access and maintain data for healthcare treatment and operations. In the past several years, there has been a proliferation of software as a service, or SaaS vendors, in the healthcare space. Relying on a cloud vendor for services was initially attractive only to smaller healthcare providers who could not maintain their own IT environment. Now every type of healthcare provider, including large hospital systems, are turning to SaaS solutions. It's no surprise that the SaaS market is showing no signs of slowing down, and it is growing nearly 5 times faster than the traditional software market, and expected to surpass $112 billion in sales by the end of 2020. Since SaaS vendors are a core part of most IT strategies, it is important that healthcare executives understand the risks associated with these contracts and be able to mitigate their risk contractually. Health IT vendors represent the highest area of risk in an organization's cybersecurity structure. There are numerous cases involving breach and compromise stemming from weaknesses in the vendor's IT structure to misuse of credentials by vendor employees. Accordingly, the focus of this presentation is to assist you in evaluating a vendor, understanding key terms, and negotiating a healthy agreement that protects the interests of your organization and your patients. Due diligence means that you do your homework on the vendor before entering into an agreement. Knowing the vendor and their capabilities is very important because 63% of data breaches are attributable to a third-party vendor. Here are some important questions to ask. What is the vendor's reputation in the industry? How long has the vendor been providing the service? What does their client list look like? What is the experience level of the vendor and vendor's leadership team? Do they have a long list of references? Ask to speak to references on your own, or better yet, pull your own references from your professional network. Does the vendor have any history of privacy breaches or fines? Do they have robust security and data protection policies? Who else are they accountable to? Do they have any certifications? Share this information widely as you make your decision whether or not to proceed with a particular vendor. This slide contains what I call the vitals for your agreement. These are the hot buttons in your agreement. These items should be on your internal checklist for all of your IT negotiations. I will be going through each of these items in more detail on subsequent slides. When you sign an agreement to put your data in the cloud, you are trusting that the vendor has the necessary safeguards in place. Despite massive and growing investments in cloud applications and services, A recent McAfee study on the state of cloud adoption and security found that only 23% of organizations completely trust their cloud vendors. My favorite motto is to trust but verify. Seriously, I use this philosophy in both my work and personal life. You must do your due diligence on this vendor in the courtship phase and again in reviewing the final contractual agreement. Don't take promises on face value. There are a variety of ways you can be certain that a vendor complies with security standards. There are multiple independent certification and accrediting bodies that audit a vendor's security platform and give it a seal of approval. I'll review some of those organizations on the next page. Many companies perform their own security and readiness assessment of a vendor. That can include reviewing the vendor's policies and procedure, the vendor's HIPAA compliance plan, and asking many questions such as where is data stored? Is anything stored offshore? What are the backup processes? Does the vendor have an incident response plan? Does the vendor have a disaster recovery policy and plan? If the vendor's sales personnel can't answer these simple questions, you can be fairly certain that the vendor's data security plan is not robust or well documented. Now I'm going to start what I call the alphabet soup portion of my presentation. Data security standards involve a whole host of acronyms. There are several certifications that demonstrate whether or not a vendor has robust data security standards. The ISO 27001 is considered the gold standard for IT certification of an information security management system. ISO certification demonstrates that the vendor has a robust framework of policies and procedures, including legal, physical, and technical controls that govern its information risk management processes. Many smaller or newer vendors have not yet developed their infrastructure to meet these requirements. It is also expensive for a vendor to achieve and maintain ISO certification. Another well-known certification that is less expensive and considered a minimum security standard is the SOC 2 Type 1. SOC stands for System of Organization and Controls. SOC reports are internal control reports on the services provided by a vendor and provide valuable information to assess the risks associated with an outsourced service. Usually a third party audits and reports on the cybersecurity risks associated with the platform. Both SOC 2 and ISO 27001 are reputable, independent, third-party certifications that attest to the vendor's level of security as an organization. These certifications should give you some assurance of the maturity of the vendor's organization. There is also a fairly new verification standard that is gaining prominence that is primarily known for web applications. That certification is the Open Web Application Security Project, also known as OWASP. Look for that certification if you are using mobile apps for PHI. On the previous slides, I reviewed ISO and SOC, which are data security standards. HIPAA is the Health Insurance Portability and Accountability Act and is the most well-known compliance standard for data protection. HIPAA is a federal regulatory requirement outlining the administrative, physical, and technical safeguards that must be in place to assure the confidentiality, integrity, and availability of electronically protected health information, or EPHI. The Health Information Technology for Economic and Clinical Health Act, HITECH, is a companion legislation to HIPAA that addresses technology implementation. HITRUST is yet another acronym, and it stands for the Health Information Trust Alliance. This is a private company and not a federal regulation. NIST is the National Institute of Standards and Technology. It is a subsection of the U.S. Commerce Department in charge of promoting and maintaining measurement standards. Healthcare organizations that work with the federal government must also meet the NIST compliance requirements. It is very difficult to evaluate whether or not a vendor meets the robust requirements of HIPAA and HITECH. This is where HITRUST comes in. HITRUST is a certification that is highly sought after by healthcare providers, health plans, and vendors because HITRUST combines best-in-class risk management and security controls from HIPAA, HITECH, and NIST. If you are using a vendor for confidential EHI, a high-trust certification is essential. HIPAA violations are a significant risk for your organization. You will want to address the issues identified in this slide in either your contract and/or the business associate agreement. If you are using a boilerplate business associate agreement, such as the one available on the hhs.gov website, it will not contain all of the necessary protections such as cyber liability coverage, definitions of damages, and the business associate's obligation to cover all of the costs of a security breach. It is imperative that you have your own business associate agreement with every vendor that touches this important information and protects health information. Just having a business associate agreement doesn't necessarily get you off the hook. HIPAA requires a provider to do what they call technical due diligence before sharing protected health information with a business associate. That is why I have spent so much time reviewing the data protection and data security standards with you. Technical due diligence means the provider has questioned the business associate to make sure the appropriate safeguards and policies are in place to protect any sensitive data shared with them. To summarize the data protection and security concerns from the previous slides, I recommend that my clients have a general catch-all phrase in all of their IT agreements. Healthcare clients should require their agreements to contain a general security clause that covers, at a minimum, the following. 1, routine backup and archiving for a minimum specified retention period, as well as an off-site retention. 2, industry standard security at all data centers. 3, network security and firewall protection. 4, ongoing maintenance of all operating systems and applications at vendor-supported levels. And 5, regularly scheduled penetration testing and remediation of any vulnerabilities. This catch-all provision allows the customer to maintain a minimum set of security standards across all their vendor agreements, and it is helpful language to point to should there ever be a security incident. You can also specify continued certification with ISO or SOC and HITRUST. I often recommend a termination right for the customer if these standards in the catch-all clause are not met by the vendor. One other area of risk that I want to briefly mention is associated with offshoring data or sharing protected health information with a vendor that has overseas operations or personnel. This photo of a message in a bottle is my weak attempt at cyber humor. This was not an encrypted bottle. Did you know that there is no legal requirement for vendors to disclose their use of offshore vendors or for staff providing offshore data or service? You must ask. I recommend that you add language to your agreements, ensuring that onshore vendors will not subcontract with offshore vendors without your written permission. You need to know where the data will reside and the risk of transmission overseas. The Office of Civil Rights has enforcement authority for violations of HIPAA, but it does not have jurisdiction on overseas companies, so any liability will fall to the covered entity and the primary business associate. If you must use offshore resources, obtain cybersecurity insurance that includes coverage for potential breaches of offshore data. Also, be aware that Medicare Advantage requires providers to submit an attestation regarding the use of offshore contractors. Be sure to identify any type of clinical service that may be provided offshore and consult with your legal counsel to determine if that service needs to be identified in a Medicare attestation. The next topic is a reminder to review your IT agreement for any attempts by the vendor to limit liability. You might see this in the agreement listed as possibly a dollar amount cap, or vendors might seek to limit contractual liability to the cost of the subscription or amount of fees paid under the agreement. This type of remedy is woefully inadequate in most situations and won't come close to even covering the expenses related with a HIPAA breach or Office of Civil Rights fine. Therefore, you do not want to accept liability caps or carve-outs for HIPAA breaches. If the vendor has any liability caps in the agreement, you must specifically state that in the agreement that caps do not apply to HIPAA breaches. A cyber liability policy will cover the costs associated with data breaches and cyber attacks and includes coverage of any violations of breach notification laws, HIPAA, or any of your privacy policies. These costs include notification, public relations, and credit monitoring expenses, as well as civil damages and possibly OCR fines. Most cyber policies will also provide access to cyber forensic experts after the breach to understand how it happened and what can be done to make sure the issues don't repeat. You would be shocked to know how many vendor agreements I have reviewed that did not even mention cyber liability coverage. I even had a negotiation with a new startup EMR vendor that didn't have any cyber coverage. We halted negotiations until they purchased coverage. A healthcare IT contract should include a provision requiring the vendor to maintain a minimum threshold of cyber insurance. How much insurance is required depends on the number of records in your practice and the total exposure to your entity. Both the vendor and the practice need to have robust cyber liability policies. Carefully review your policies to make sure there are no carve-outs. For example, inexpensive policies often seek to carve out ransomware or other criminal activity. This carve-out undermines the purpose of seeking this coverage in the first place. When negotiating your contract, think about the importance of uptime. Remember, this is a cloud system, so if it is down, you are not able to access any of your data. Think about how that will impact your operations and how you will design your backup plan. For example, you may want to develop downtime procedures about how you'll operate when the system is not working. The timing of planned downtime is important as well. For example, I worked with a hospital that updated its software at 2 a.m. on Saturdays. The vendor thought that this was a great time, but it also happened to coincide with the busiest time in the hospital's ER. Instead, we moved the downtime to midweek, early morning, when it had less of an operational impact. An uptime warranty in your agreement should address the following: a definition of scheduled downtime, specifications for the maximum amount of scheduled downtime over a specified time, a guarantee of no downtime other than mutually agreed scheduled downtime, and a very low percentage of scheduled downtime. There should be a defined process for responding to unscheduled downtime, as well as a timeliness for resolving any issues. Ask whether there's redundant backup data and software, whether that's included, and the circumstances under which that becomes available. A definition of when the failure amounts to breach of contract is important, and so should be the corresponding remedies for breach. I would like to just mention a few issues related to termination of the agreement. It is important to think about this step as your prenup agreement. Ask yourself, in the event of termination, how will your organization access this data? You are going to need access to your personal health information and any patient data, billing records, any type of information for billing compliance, audits, and general compliance purposes. So how will you access data after termination? Is there a particular format that you're going to need? If so, designate that format in the agreement. You also may need a team to help support transferring data. If so, negotiate that into the agreement. You may also want to negotiate backup rights to the data so that the data storage can be retrieved. One other consideration is to withhold final payments to the vendor contingent on their cooperation in transitioning data. You have to be very specific about how much you'll retain and how much will be withheld until the data is finally transitioned, and you'll want opportunity to test the data that has been transferred, that you can still access it. As I close my presentation, I want to give you a few tips on negotiations and pricing. Healthcare executives purchasing new SaaS solutions should expect prices to come down with significant discounts, especially for providers that have spent money responding to COVID. This is a very tough time for software providers, and they are becoming much more flexible in their pricing strategies. Be sure to research the vendor's discounting practices. Some vendors are known for broadly applying discounts as a standard practice, so it sounds like they're giving you a good deal, but they may be offering you what's their standard discount. They may come out of the box offering a 40% discount, and that's what they offer to everyone. If that's the case, that discount is really meaningless, so don't be excited about large discounts. Be sure to protect pricing on additional products and services that you anticipate adding in the near term. If there's an upgrade that's required or another companion piece to the software that you already know you want to purchase, negotiate the prices for all of those items now and include them in this agreement. Look carefully at multipliers on annual subscription costs. Many vendors include an annual escalation. Recently, there's been a trend to use the ECI, Employment Customer Index, which is usually higher than the Consumer Pricing Index. This benefits the vendor, not the provider. Make sure that the multiplier that's selected is what works for you. Also, add an all fees clause. This essentially states that the cost is what it is. It ensures that there are no hidden costs necessary to procure or implement the technology. This means they've identified any software, hardware, or ancillary items that are going to be necessary to operate the software. This is my last slide. I'd like to close with a few practical takeaways. First, I suggest that you draft your own checklist for use in reviewing vendor agreements. Go back to that vital slide and look at those key terms. Require your team to consistently use the same checklist when reviewing all vendor agreements. Next, be sure to create your own standard provisions that satisfy your privacy and security requirements, and ask the vendor to use your language. Never just accept the vendor's boilerplate template. It is obviously written to benefit the vendor, not you. My other suggestion is that you keep other vendors in the loop during negotiations, so you have a backup strategy and can walk away if the vendor is not agreeable to the language that you require. Another point related to that is to never sign a letter of intent prior to executing an agreement. A letter of intent is just a vendor strategy to lock you in and stop you from continuing to negotiate with other vendors. It is in your best interest to continue talking to as many vendors as possible. There are some good tools and resources available for negotiating IT contracts if you're unable to retain legal counsel. If you are a member of the Texas Medical Association, you can get some assistance in negotiating from the Coker Group as one of your membership benefits. You can also go to the ONC website and CMS websites to look for guides for negotiating EHR contracts. Those are all available online. Thank you for your interest and attention today. I'm happy to address any questions at this time.